Or okay, got it. We will assemble in person at the Kensington Library. That just applies to members of the board, members of the public will still be able to continue to access the meeting electronically. And just to confirm that we're going to meet on the last Wednesday of the month going forward. The next section is citizens' comments. If there's anybody here who would like to make a statement or ask questions of a general interest, not related to agenda items, this would be your opportunity to do so. Ready, set, go. Anybody? Excellent. That's a sign of a well-run organization. No complaints, no comments. The next item is the approval of the meetings, notes from November 29th of 2022. I will have to confess that we do not currently have those for consideration. And so we will have to bring this back up at our March meeting if there is one. Does anybody know anything else about the status of meeting notes from November 29th of 2022? No. Okay.
I'll just jump in on that, Lloyd. I think the problem was that was Patrick's last meeting as chair. And so presumably he was responsible for those notes, but I think that he may have, I think his service may have ended. Fortunately, we record all meetings. This one has been recorded for posterity and we can derive helpful notes from that.
Okay, that's fine. And I know that Patrick had given himself the task of taking notes in addition to running it. I don't know if I'm quite there yet. So would anybody like to volunteer to take notes so that those can be recorded, approved, added to the record, and made available for members of the public to view going forward? Chris, Ben, anybody?
I have not seen notes taken for, this is my first one. I haven't seen notes from prior ones yet. Like I haven't had to review them. So like I'm a little nervous about capturing things properly because I tend to write rather abbreviated notes, but if you will just accept whatever I do, I'll take some notes.
Okay, well, if you'd like to give it a shot, I'm sure that you'll be up to the task. It's not a terribly complex or difficult task. It's just something that needs to be done because we're a public board and this is a public meeting and we have to do it. So are you good to go on that basis?
I will give it a shot. I'll just.
All right.
And could I jump in on that, Lloyd, real quick and just say, thank you so much, Ben, for your bravery jumping in on that on your first meeting. And fortunately, for additional support, not only do we have the templates that we've used, we'll provide that, but also the best part is since we record the meetings, you don't need to worry about the notes during the meeting unless you'd like to. You can obviously just get that from the recording afterward if you'd like. Thank you.
Sure.
All right.
And by the way, the notes just need to be really a summary of action. It doesn't need to be a blow by blow. I mean, when people speak, for example, public comment, you can just indicate, so-and-so spoke for a project, against a project, or some specific comments, but you can pretty much, it's summarizing the actions of the MAC.
Okay.
Excellent. All right. Let's move on then to our one main agenda item, which is a presentation of proposed changes to Contra Costa County's tree obstruction of views ordinance. The red line of the proposed changes to the actual ordinance language and a statement of purpose were circulated with tonight's agenda. So I'm not going to really go over those, but turn the meeting over to the person responsible for making the presentation.
So I was going to start first before turning over to Tom Geiger, our county counsel. Can you hear me okay?
I can hear you just fine, and I'm going to unshare my screen and yield the floor.
Thanks. I'm John Joya, and thanks. I want to thank the MAC for all of its work and for the new members and today is specifically focused on getting input on proposed changes to the tree obstruction of views ordinance. And I just want to say that the county does have a broader tree ordinance that applies countywide, and we are looking at making some changes to the countywide ordinance, including putting in language that addresses the whole issue of flammability of trees. So I want to make sure that this issue before us on views is separate, and that the other countywide tree ordinance would apply in Kensington. And and I don't know, Tom, you could briefly mention that effort, but this ordinance tonight is specifically an ordinance that just applies to Kensington. And it was designed to try to address dispute between neighbors on situations when trees obstruct a neighbor's view. And it is the existing ordinance is really one that is civilly enforced. And the county doesn't have any real direct authority, legal authority, and Tom can explain that. It can facilitate a process to try to reach resolution between neighbors. And over the years, our office has received a lot of input from residents in Kensington about having an ordinance that defines a better process rather than say everybody has to go to court. And to try to see if there's a way to resolve differences through a county process that may not be binding, but that establishes a basis to get parties to work together and then go to court as a last resort. So we formed a working group of Kensington residents, which we've done before on previous ordinances, who met over a period of time with our county council and with planning to look at other ordinances in other parts of the state. And what came out of that is the red line version that you see today. And we're here to present it, hear any input. My understanding is the Kensington Property Owners Association actually did a mailing to their membership list about this meeting. That we didn't do that, they did that. But it was with the goal of getting the word out about this ordinance so people could see it. The process would be, I think, once we get input from KMAC, review that, and just consider any public input, it would go before the county, the planning commission, I believe, and Tom can explain that process, and then the board of supervisors for amending the ordinance. So I'll limit my comments to that. And if I have to jump off later, it's because I have to make a presentation at the Richmond City Council meeting, but I will stay on this as long as I can. And so I will turn it over to County Counsel Tom Geiger, who was the lawyer who worked with our work group. He can summarize the changes. And if anyone has any questions on the red line, can ask Tom. And the red line is a red line off the existing law. So it's changes to the existing ordinance, and you can you can easily track what those are. So with that, I will turn it over to Tom Geiger and stay on also to answer questions.
Okay, thanks, John. Yeah, my name is Tom Geiger. I'm the Chief Assistant County Counsel, and I worked with Supervisor Joya and the working group on this ordinance. And what we came up with was an ordinance that's, we looked at several ordinances, and I think an ordinance that the working group really did a good job was the Sausalito tree ordinance. And so some of what's in this ordinance is based on Sausalito's ordinance. Basically, the most important thing that this new ordinance, proposed ordinance does is it establishes a new arbitration procedure to resolve disputes over views that are obstructed by trees. The existing ordinance already encourages tree disputes to be resolved either informally or by voluntary mediation. That doesn't
John Joy
work,
about this.
under this. There's somebody else talking. I'm hearing like a feedback. Anyways, I'll go on.
Apologies, Tom. If I could ask all attendees to please mute yourselves while the presentation is occurring. Thank you.
All right, thanks, Robert. Yeah, so if informal discussions or voluntary mediation don't work, then a person who's believes his view or her view is blocked by a neighboring tree can submit something called a view claim to the county. And what the view claim does is it's a claim that explains what view is being blocked and describes how it's being blocked by which trees. So once a view claim is submitted to the county, a tree arbitration board can resolve that view claim. And so the ordinance has been designed to have any number of different types of bodies to be a view arbitration board. And one of the options I think in Kensington would be that the Kensington MAC could be the tree arbitration board for the Kensington area. So if there is a hearing before the tree arbitration board, then both the property owner can submit evidence, and the person who owns the tree can also submit evidence. And then the tree arbitration board will listen to the evidence. The evidence can include an arborist's report. Both sides can present arborist reports. And then once the hearing is done, the tree arbitration board will issue a written decision. And the decision will include whether, well, it'll basically include a finding as to whether the view has been blocked or not. And then the decision will also describe, if the view has been blocked, what actions can be taken to restore the view. And those are things like trimming the tree or even cutting it down. And the decision is binding if at the beginning of the proceeding, both parties decided to submit to binding arbitration. So that's the biggest change in the ordinance. It also establishes a new procedure to for the tree arbitration board to issue advisory decisions. So if the parties don't agree at the beginning to have binding arbitration, they can still either the tree owner or the property owner whose view is blocked can request that the tree arbitration board issue a non-binding advisory decision. And so if that's the case, then the tree arbitration board will hear evidence again and then issue a non-binding decision. And then either side can take that decision to court if they want to have the court do something about the blocked view. So those are the big changes to the ordinance. There's a couple of other changes. And actually there's one item that really wasn't resolved by the working group. So at some point, I think maybe the MAC will want to discuss it, or it'll want to be discussed at the Planning Commission. It's under the definition of view. So the ordinance defines view as a range of sight from living areas of the residents. And so what the working group didn't really come to a consensus was whether a view should also include a view from a deck, which is next to a residential or area in the house. So that's something that still needs to be resolved in the ordinance. The other big change in the ordinance is it addresses the Solar Shade Act. And the Solar Shade Act is a state law that authorizes if your solar panels are blocked by a neighbor's view, you can go to court and try to get an order to get the trees to unblock the obstruction of your solar panels. So those are kind of the highlights of the changes. like Supervisor Joya said, there are bullet points, I think that were attached, that were on the website, so those summarizes the changes to the ordinance, and then, like you said, there's a red line also that's on the website. So that's the summary of the ordinance, and if anybody has any questions, they can let me know.
I have a question.
Okay,
My name's Andrew. Hi, John. The question I have is you mentioned something, Tom, regarding if arbitration is not agreed to in advance, that there would be a repeated hearing. You said there'd be another process as opposed to KMAC simply saying, well, we've heard the facts once, we'll issue a non-binding opinion. Did I misunderstand that?
well, I may have not explained it correctly. So at the beginning of the process, the parties, they can agree to have the arbitration be binding.
Right.
But if they don't agree, either side can go before the tree arbitration board for the hearing. The hearing would be the same. It's kind of whether it's binding or not, that's decided at the beginning of the hearing. So it's not two hearings, it's one hearing, and it's either binding or not binding.
Okay, I understand. And secondly, if this does get approved, it would seem reasonable that there would be some sort of fee on the part of the county, like whenever you go to a planning process, there are some county fees. I'm wondering what the barrier to entry would be for this process in terms of fees. Has there been any discussion on what would be an average cost for a complainant to begin this process with the county and the appropriate board?
The costs haven't been established, but there would be, DCD would probably want to go to the board and amend their fee schedule so that there would be a fee associated with filing a view claim. So it's basically the fee would cover the cost of processing the view claim. But if the ordinance passes, then I think the DCD would go back to the board and request that the board establish a fee to file a view claim.
I see Ruben is on from DCD, Ruben Hernandez. Ruben, any sense of the range of what a fee would be? Andrew, just to respond, I think, yeah, any county process will take a fee, right?
Oh.
Because to cover the cost. Obviously, individuals can weigh what they want to do. And ultimately, as you know, the idea is to keep people from going to court, which is extremely more expensive than going through a county process if it resolves it. One of the complaints we heard from residents is, gee, the county's not involved in the process. I have to go to court. That's going to cost me thousands or tens of thousands of dollars. So remember, under the current ordinance, the only way people enforce it is to go to court, which is extremely expensive.
Right, John. But backing out to 40,000 feet, often these types of statutes are written not for the broad masses, but for that occasionally very difficult individual that is saying
Right.
to their neighbor, go
Right.
to hell.
Well,
And
but
so,
Andrew, if the neighbor says that, then they're going to go to court and spend $10,000. See my point? I mean,
yeah,
you're-
that's if you're dealing with the rational neighbor. So let's go back, since we don't want to have a big debate.
let me ask Ruben, what do you think a range would be, Ruben, for something like this? Any idea?
Well, John, I mean, generally our fee schedule is based on, the amount of staff time that would be required to prepare. It sounds like, we'd spend a number of hours preparing the claim, analyzing, putting everything together. I'm trying to think of something, John, that is comparable to, but generally I would say in the couple of $1,000s range, probably. It wouldn't be like a $500 fee, because I could imagine that there would be some, I don't want to say significant, but a few hours of staff time that would be required to prepare everything.
So
Okay, so
when
let's do
the Sausalito ordinance was reviewed, did anybody find out how much or if at all, do they charge in order to engage in this process?
Good question.
Yeah, working things out with your neighbors is free until you get the government involved.
Exactly.
Well, let me just say, I think you're operating under assumption that things can be worked out. The idea is nobody has to take this to the county unless they choose to. And people can choose now to work it out with their neighbor or go to court. This would say, work it out with your neighbor. Of course, you want this worked out with the neighbor. And the only reason, again, that we were asked as a county to present a process is because when people don't work it out with their neighbor, they go to court. And as a former lawyer from 20 years ago, I can tell you, and I'm sure there's a bunch of lawyers on this, that it's not cheap to go to court. It is way more expensive than a couple $1,000s. So the idea is you wouldn't need this process if you worked it out with your neighbor.
Right, right.
This is only designed, Andrew, when people can't work it out.
No, I know that, John, but what I'm thinking about here is, does this change represent additional amount of leverage for a complainant? In other words, don't take my language really literally, but in other words, if I have a neighbor that says go pound sand, and I don't want to go to court because I know it's very expensive, and I think, gee, I can go to the county and pay $2,000 to set this up, get it going, and the neighbor says, well, fine, I'm not participating, I'm not agreeing, too bad. Then my choice is sue them myself and avoid the county, or assume that I could get a favorable decision from the board, and that somehow that gives me a better chance when I do finally go to court. So I'm still going to court, right? I'm just trying to figure out what the added value.
I just got a note that several people couldn't access that because the link was embedded in the document. And so
That's right.
we sent them the link. And so I think there's other people getting on. And I think, Robert, did we put a new link on the website for folks?
Can I speak to this just for a minute?
Yeah.
Yes, thank you.
I tried to join this meeting at 6:45, and the phone number on the Contra Costa County site to connect to you guys didn't work. The Zoom message that had been sent to me a week ago didn't work. I finally called Robert Rogers just before the meeting and was sent the appropriate link, but I am very concerned there are other people in my condition, that you're not really getting a full representative sampling of the people you were trying to. I don't think this is right.
So the phone number works, as I've seen. I think the problem was that the link is correct. It just wasn't a hyperlink in the document, and Robert sent out the hyperlink. And so I think we posted that on the agenda. It's on there now, Robert, the hyperlink?
Yes, thank you.
Okay.
Neither worked for me, but can I also ask a question while we're talking about finances here?
Yeah.
All right. I've lived here since 1994. I've inherited 2 large redwood trees when I moved here. One was pre-1994 or 1984, and the other one maybe. I got rid of a bunch of Monterey pines, but I have a neighbor who continues to complain. I trimmed the trees just recently, but he's never wanted to pay any money. I believe that I'm still concerned because although I believe that I don't need to cut these trees, and I think you could perhaps help by telling the neighbor that he doesn't have a claim because they're pre-84. I am also worried that sometimes advisory boards do funny things. So if the advisory board was to compel me to trim or remove the trees, the cost is going to be substantial to me. We're talking $20,000 for tree removal. We're talking $20,000 to $30,000 for slope stabilization and replantings. What I'm concerned with is that although the ordinance seems to imply that since the trees were here before I moved in, my neighbor would be required to pay, there's nothing that addresses that responsibility responsibility that he has. I might be advised or compelled to start work within 30 days, but nobody's talking about how the payment issue will happen. The issue of financial responsibility needs to be addressed. How would it work? What if my neighbor gets me to do this work? I hire the tree man, he sells his house and leaves. I may be stuck with a lien on my house at the need to sue somebody for the payments. I would not want to start my job unless I had a surety bond for the amount that was required. So I would like to suggest that this ordinance includes something not only about me having to do work if the board wants me to, but also that the person who is required to pay be required and enforced to pay rather than me having to go to court and maybe never get my money back. Thank you.
So Lloyd, let me make a suggestion. My understanding is there would be a presentation, questions by your KMAC members, and then public comment. So we're now in public comment. I want to make sure, are you then, were there any other questions from KMAC members and then the idea is to have public comment, which could involve asking questions. And the whole purpose of this is to take note of people's questions and concerns and see about answering them also, if not tonight, at a future meeting. So I just want to make sure, were there any more questions specifically regarding the ordinance from your MAC members before opening it up to public comment?
That's fine. Yeah, we seem to have attracted a lot more people into the meeting than when we started. The one question that I did have was, does the county know the numbers of cases, for example, that come out of Kensington currently? And since it looks like it's being considered to ask the Municipal Advisory Council to handle these matters also, I mean, how many cases do we see? There's been some discussion about the stick in the mud neighbor who won't help and that sort of thing. I mean, are we really talking about a lot of cases, or is this just an occasional thing?
Yeah. And by the way, I don't know if there's any members of the working group who later on may want to add any comments, because they were the ones, these are Kensington residents, both who come from the perspective of trees or views or both. I think, fair to say, because I don't know if the Department of Conservation Development has gotten those complaints, because the current process does not involve the county, right? It involves going to court. The county we don't know exactly how many people have disputes. What we do know is, our office over the years, and Kate Rauch, who lives in Kensington, who's, worked in my office, fielded a number of calls over the years about people asking about the process or complaining that there wasn't a more defined process. And I don't know if others who've been involved want to make a comment. Gail, I see Gail Feldman, president of the KPOA. So yeah, we would get calls into the office, but there's no exact count, just because the process currently doesn't involve the county.
Okay, fine.
Gail,
That's the only question that I have.
Yeah.
Before we open it up again to the rest of the public, does Chris or Ben, and I saw Adam sign on, does anybody else have any questions for the county attorney or our supervisor regarding this before we start taking more public comment?
Mine was going to be similar to the last speaker. I think if this is a red line to the existing ordinance, I believe the existing ordinance does speak to the how costs are dealt with, but I don't know. I think clarity around that would be helpful. So that was something I'd to say was that, did we look at cleaning that up a little bit? Because I do think it indicates there's whether it was planted before or after 1984, who bears kind of the cost. I think there was either 100% or 50% allocation of cost, but that still doesn't solve the problem if nobody comes forward with the money. So that would be something, if we could add that may solve something. I don't know if we can, but I think it would be good to spell that out and be clear about how people can address it. Whether the county, the court, or whoever resolves it, how we move forward with that.
Yeah, I think these are all good points to make. So Robert, someone should keep track of all the issues that are being raised tonight. And the whole purpose is to take note of the issues that have been raised tonight. And then if they're not answered tonight, to look at bringing the work group back together to discuss any of the issues that were raised tonight.
Thank you, will do. And for the chair's benefit, just want to let you know, Paul and Vita have their hand raised, and then Gail Feldman.
Okay, yeah, and we're requesting that people identify themselves for the record, right? So I would maybe first and last name and Kensington address in the chat, so we can make sure those get into the notes. And if Robert, if you saw Paul and Vita's hand up first, let's let them go ahead and talk. If you are a member of the public and would like to make a comment, please do raise your hand visually in Zoom, or somehow indicate. I know we have a lot of people here by telephone, so let's try to work through people here on video, and then we'll talk to the phone people if that's all right. So Paul and Vita, you're on the air.
Yeah, thank you, Lloyd. Can you hear me okay?
I can hear you fine.
Yeah, okay. First of all, I applaud the county for taking this up because the current ordinance has been largely ineffective at addressing the subject matter that's concerning a lot of people, given our topography here in Kensington. I'd like to second what Chris was just saying about addressing costs. One of the problems is that the current ordinance has no teeth. There's no way to really compel a neighbor to, compel is too strong a word, but to strongly encourage a neighbor to engage in mediation or arbitration, because there are no teeth in the ordinance. And this provides a little bit of bite in the advisory findings that create a rebuttable presumption if you do have to go to court to get relief, whichever side of the dispute you're on. I think that the current formula for allocation of costs actually is just an invitation to a post-decision scrum over whether the tree was planted before or after a certain date in the 1980s. Who knows? Many of the trees in Kensington are volunteers. And I can see now an argument consuming more resources over, well, we didn't plant the tree, it was there when we bought the house, and so on and so forth. Why not make the allocation of costs subject to the decision of the arbitration panel or the recommendation, if it's a non-binding decision that can take into account all sorts of factors, including the potential recalcitrance of one or the other of the parties to come forward and engage in a peaceful and neighborly resolution process. Thank you very much.
Okay, Paul, can we get a note of your local address for the record, please?
Oh, absolutely. We're on York Avenue, just off of Westminster.
And I want to be clear, notify people can give their address, but they're not legally required to. So I just want to note that.
Okay.
Okay, I guess I'll put my hand down and speak. It's Gail Feldman, and I'm a Kensington resident. I was also on the committee that helped draft the ordinance. I would also just like to let everybody know that the new Zoom link is on the website now, and apologies that the link that was on the KPOA email was incorrect. That was what we had received previously from Robert. So hopefully that got corrected, and everybody who wants to be on this call is on this call or on this meeting. So I just wanted to address a couple of things just to answer your question, Lloyd, about how many of these kinds of disagreements occur. It's really hard to know, but I was president of the Kensington Property Owners Association for about 20 years. And so we fielded a lot of these calls. I fielded them personally. And I would say, you know, we're talking at that point in time, maybe a few a year, you know, maybe at most, I'd say 10 a year, where people were having issues around particularly view obstruction with trees and having just difficulty negotiating with their neighbors. And so often what I would do would be to just explain how the ordinance worked, to give them some, ideas. And then as I got more calls over the years to understand how people were resolving these conflicts, if there was anything I could impart to that degree. So I don't think it'll be an overwhelming amount, but you never know. Things have changed. Trees have grown taller now in Kensington, as well as new people have moved in. To address Mr. Doro's point, I think the reason that we continue to use the 1984 year is that we weren't going to, I don't think the committee was thinking that we were going to give a new right to a view. So if, for instance, you moved into a home where the tree was already blocking the view as of the time that you moved in, we wouldn't be wanting to set up a system or a situation where people would want to regain a view that they didn't have. So I think that's the problem of, trying to figure out, well, what year do you use? I don't know if it's necessarily a year, but it has to be something where you don't have the right to argue necessarily for a view that you didn't have when you first bought your property. So, I don't know, there might be other ways to solve it if it's not a year, but I think that's why we just kept the old language in the ordinance. The only other thing I wanted to say while I still have the floor here is I do encourage that the Cape Mac consider being the tree arbitration board, although, that's still up to the Board of Supervisors how they want to set those up. But to me, it makes sense to have the same body that deals with view obstruction issues on the construction side, also have the same ability to make determinations for trees. So it seems like they go together. It's sort of the same ideas and same criteria, more or less, that we would be using. So it makes sense. I hope that the KMAC would be supportive of that. Of course, you're on this board for a short period of time, and over time that might change, but it does make sense to me that it's one board that makes those determinations. And I'm happy to answer any other questions as having been serving on that committee, but I'll let others speak. Thank you.
Ben, did you indicate that you wanted to ask a question while we're at this point in the conversation?
Yeah, just a really quick one, and we might not have the answer. And so the overall question is basically, and I have read the changes to the ordinance. I didn't notice it. I might have missed it, but I am aware that there have been a number of situations over the years where parties where there's been a dispute related to trees have taken matters into their own hands and might have taken action and either poisoned or cut their neighbor's tree for their purposes to create their view. And so is that something that we need to be also considering here, where like there would be some kind of arbitration where an action has already been taken rather than like asking for an action to be taken? So I'm just asking that question.
Let me ask Tom Geiger. Tom, what's your thought about that?
Well, if somebody's poisoned somebody else's tree or just taken, trespassed and taken matters into their own hand, that's a crime. So, this ordinance really wouldn't address that. That's a really different issue that if that happens, you might want to call the police or DA, but that's a crime.
Okay, thanks.
So where are we? Is it Joseph or Andrew who is next?
I believe it's Joseph, then Andrew. Andre, I'm sorry. Or no, Andrew, you're right. Thank you.
All right, so we'll hear from Andrew Reed now, please.
Can you hear me now?
Yes.
Good, sorry about that.
No worries.
I want to support some of what Gail was saying. I do think having that landmark 84 would be good to leave, because I have seen things happen in the neighborhood where a person moves into a new home and starts to create a view they didn't have. So that has to be addressed for sure. I also, on a separate note, I remember working with John and Jim Carmen on the view ordinance, the overlay. And at the time, we realized that a lot of suffering takes place because when people come to our community and they buy a new home, they aren't educated. They're unaware of a lot of things. Most people don't know there's a overlay ordinance for view, light, privacy, etc. Most people don't know there's a tree ordinance. And so they settle in and they begin their planning, and lo and behold, there are conflicts. So my question to John Joya and to county representatives as well as KMAC is, years ago, Jim Carmen and I were talking about how do you distribute this information to prospective buyers? What can be done to put this out there? One idea had been that the real estate trade would somehow have to let people know that this exists. Do you folks have any comments about ways that we could educate people to prevent a lot of the misunderstandings, wrong expectations, and conflict? Because we're dealing with the back end here. What can we do on the front end? And then third and last point, I know I'm a broken record, John, and the rest of you. I think if this were to be an improvement on our current situation, that we should do something to make the application fees for this process very, very reasonable, so they're not a barrier to entry. This isn't exactly like spending $2,000 to start a remodeling application with the county where you're going to add something to your house and you get that value. Yes, it is potentially conserving a value you had when you bought your building, but I think it's a little different. And if it's 2,000 and then the clock starts and it's 3,000 and 4,000, I don't know how much this is going to help, because we are a community, maybe 30% of the community is on a fixed income. Thank you very much.
Thank you, Andrew.
I think we will go back and look at the fee issue. I think Department of Conservation Development has to look at what is a cost for that, and how to try to make the fees as reasonable as possible while still compensating the actual costs. So I think that's worth looking at. And fees end up being obviously more than we always want them to be, but I think they can take a look at that issue. As to notify, yes, I mean, realtors are the best way to notify people of requirements, but realtors, don't want to be required to do so. Remember, I sponsored an ordinance that requires in the unincorporated areas, at time of resale, every new home has to install excess flow or seismic shutoff valve, gas valve for their house, so that the gas would be shut off in an earthquake. We faced resistance from realtors. We passed it anyway, and realtors have come to live with it. And because it's a noticing that they have to do, and people have to do it on resale. So I just say that because I think realtors will tend to push back, but some will do it. I think some will have a package. One of the things I used to do that I think we're going to start doing again is we've gotten a list of those who when people buy a home and it's closed, of sending them like a letter. We haven't done this in a while, about the county, where to get information. And maybe we can adapt a letter like that for new people who buy in Kensington, to let them know about the ordinances that exist or where to get more information. So that we could do when we start doing these letters again. So that's and then we can ask the help of the Kensington Outlook to occasionally put out information about it, because I would venture to say there's a lot of current residents, not just new residents, who don't know these requirements. So I think working with the Outlook, working with KPOA to send mailing out to residents, I think we can try to use all those channels and to get the word out.
Okay, so our next speaker then, Mr. Joseph Holmes.
Hi there. I'm Joseph Holmes. I live at 14 Highland Boulevard in the north side of Kensington. And I was just wondering, do you all think that, John, especially, do you really think it's impossible not to cut the baby in half? Because inevitably this makes the entire problem so much more complicated. Either it seems like if we want the business of what to do about trees to be practical, something we can actually manage and afford in terms of not just dollars, but time and headspace, we should either have the unfettered right to grow trees however we want, or we should own our views. And I think here it would be much more important to own the views. And I'm not just saying that because we don't have trees, we do, and we cut them all on a regular basis to preserve everybody's views. You know, but I mean, you can't obviously, if somebody like, you know, one of the earlier speakers, you buy a house that's got 2 giant redwood trees on it, you can't just be saddled retroactively with the obligation to cut them down. But it seems to me that it makes much more sense for everyone to be responsible for having their trees not get bigger. It just, any other way that you do it would be inevitably much more inefficient.
Right. No, I mean, all good. Let me ask Tom, Tom, there are, you know, some legal parameters about what we could do and what people's right to a view with regard to trees are. Now, our general plan with regard to development did build in a view protection. Remember when we, as Andrew made reference 15 or so years ago or more, when we developed the zoning overlay ordinance, which requires everybody who's going in to build a home or modify their home, building envelope of their home, to consider its impact on views. Previously, that had not existed in Kensington, and we put in policies in the general plan to support that. So maybe I should ask Tom Geiger to talk about what limitations the county has on issues of view protections and trees, because there's some legal issues. The issue with trees is different than with development.
Right, and I think it really comes down to, under state law in California, you know, property owners, you actually don't have a right to a view from your property. So, I mean, I think that was kind of the underlying assumption that's behind this ordinance, trying to get people to work together to restore views.
And explain to people why we're able to put in some view protection policies in the general plan that apply to development and why it's different here with trees.
Right, because that is you're building something, and the county is allowed to kind of regulate height and other things like that when they're regulating development on property. And so if one of the ways you can regulate development on property is considering the view from somebody else's property, and so you can regulate the development on that one parcel by taking into consideration the view from another person's parcel. So that's the difference between development, new development, and then trees growing on people's property.
What do you think? What do you think of the comment of this last comment regarding this? You know, either you own it or not. About his comments on solutions. What's your view of that?
Well, I mean, I think that the assumption there is that if you have a view or you want a view, you can tell somebody else what to do with their trees on that person's property, and that's just really not how the law works in California.
So we don't actually own our views after all.
Yeah, that's the basic law in California. Yeah.
And if we did, so ultimately, if we didn't have this procedure, somebody could have their tree grow and block your view, and then there's nothing you can really do about that. Is that correct?
That's right. I mean, I think when I say that you have no right to view, I mean, the legislature can take steps to change that. I mean, they did do that with the Solar Shade Act because they think that solar having, you know, solar power is more important than you know, having people being allowed to grow trees on their property. So the legislature made an exception to the rule that you don't have a right to view by saying that if your trees are blocking somebody else's solar panels, the owner of the solar panel can go to court and get the tree removed.
Right. So I think that was the struggle, just so everyone knows, in working on this, was how do we create a process that really tries to encourage mediation. So yeah, and Andrew posed a question. So a court proceeding would find no right to an existing view. through trees. And without an ordinance, let's take away the ordinance for a second, and looking at what it currently exists, the civil, how would you answer that, Tom? Given what we currently have in place, which is a civil mechanism, this question is: a court proceeding would find no right to an existing view with regard to trees?
Well, I think, yeah, without the ordinance, I mean, there would be really no way for people to kind of, because views are important. There would be really no way for people to come together and try to work something out where, you know, one property owner gets, you know, at least part of his or her view, and,
Right.
and the other person gets to keep, you know, part or most of their tree.
Right. And so this ordinance, the ideas that the working group put out, a lot of this was based on Sausalito. I mean, a lot of this was taken out of the city of Sausalito's ordinance, and you can look at theirs, was to try to form a process to get people to agree. But ultimately, if people don't want to agree, that conflict will continue. A lot harder dealing with trees, we found, than with development, where we have power to say when someone's adding on to their home, and KMAC knows this very well because this is what they deal with all the time, is, you know, people need to try to, you know, design their development in a way to minimize the impact on people's light and air and views. And we can do that. And I think the ordinance has overall been successful. I mean, in the 18 or so years that ordinance has been in effect, I've only recalled 2 or 3 matters being appealed directly to the Board of Supervisors. So they've gotten resolved at a lower level, which is a good thing.
Right.
For what it's worth, John, I think that the ordinance is great. I think it's incredibly logical and very well conceived. Yeah, and I mean the other ordinance, when you were just talking about the Kensington combining ordinance.
Yeah. Andrew recalls many meetings in my conference room, and others of you here too. I think Gail, you were there, and to get to work through that, and it was a good process. This was a little harder. The working group, I think, was really thoughtful on this issue, but also understood that there wasn't the same legal authority that the county has.
I presume that if the legislature were to do anything about the trees, that we would be 20 years, you know, off in the future, and that we wouldn't get our views back that were lost 10 years ago.
Yeah, I think the legislature right now is focused right on a lot of issues, including housing, and I don't see that. I have not heard their interest in getting in the middle of this dispute.
I'm sure.
All right, we want to hear from Gail Feldman, please. You'll need to unmute.
Just wanted to also make a comment and answer some questions, some things that came up earlier. One of the things I think about the changes, the revisions to the ordinance that I think would be helpful is the fact that there's also an option for fact finding. And that's really something new. And I think that having, you know, arborists come in and give opinions and really help people to resolve some, you know, it's hard to know exactly what all the conflicts come from, but that's a new thing that would really, I think, aid both in resolving the conflicts, and certainly if people decided to pursue their disagreements in court, would aid the parties in resolving those conflicts in court, hopefully quicker than some of the things that I've heard have gone on for years with different complaints that have gone through the court system about tree blockage. There was one comment that was raised about how you get the parties to pay for the work that would be done to trim or remove a tree. And, you know, just one thing, I don't think that really necessarily needs to be addressed in the ordinance because, well, not only will it be part of the binding arbitration if it goes through that process, but typically the contractors who do the work will, you know, actually have contracts with the individuals who are going to pay for it. So to me, that seems like a better remedy because they have the ability to put the liens on properties if they don't get paid for the work. So, you know, it's just something to think about for, you know, especially if you're a tree arbitration board, is that the way you can usually work around that is that the contracts just are directly with the tree trimmers themselves between individuals. So, you know, I guess that to me just seems like a more practical way to address it. And finally, I was just wondering at some point in the meeting, John, if we could hear about what the next steps are going to be with the process, because the ordinance has been through this process now for quite a while. And, you know, I think it's time that we move it forward. So just would like to hear from you where you think the next steps.
Well, I mean, the way I viewed was that this, the KMAC was going to be an opportunity to have KMAC discussion, any input from KMAC and from the public through this public hearing process, and then maybe take it back to the work group with the issues that have been identified from this hearing. And there's been a few, and I'm going to ask for input on one issue specifically. We'll get to that, and then look at any final recommendations. Ultimately, it would go to the Planning Commission and then the Board of Supervisors. Is that correct, Tom?
Yeah, that's right. And then when it went to the Board of Supervisors, I mean, I think that that would be the same time that the board would want to consider in Kensington who to designate as the tree arbitration board.
Yeah, so let me ask two questions for input. One is, how does the KMAC or anyone who wants to comment on this feel about having KMAC, which currently their role is making recommendations under the current ordinance, the development ordinance. So, you know, they're familiar with that, and new members will be learning that. And we'll do a training. Is whether to have KMAC also serve as the tree board that we establish, or to have a separate tree board of Kensington residents with people specifically interested in that issue. So I'd be interested to hear both from KMAC about that as well as from the community. And then the second issue, Tom, we have in the ordinance, we wanted this input about view from decks. So can you restate that? Because I remember we wanted to flag that issue for public input.
Sure. So right now, a view is defined as basically what you can see from the living areas of your home. And so the question is whether a view would also be something, you know, what you see from a deck that's connected to your home.
Because that then would broaden the view protection and potentially obviously have more impact on trees. So that was some input, is how do people feel about whether the view protection should be extended to a constructed deck off of somebody's living area. Any thoughts?
Well, John, I'll go to your
For
first.
the community. Yeah. Yes.
I'll go to your first comment. I would agree. It probably doesn't make sense to create a secondary board.
Yeah.
I think Gail said it earlier. We're already making decisions, you know, for new construction, other around view, solar, and obstruction, that kind of thing. And we have a hard enough time staffing this one. So we're a small community, right? So I think creating a secondary board wouldn't be really make that much sense for what won't be that much
We'll
more.
just give it to the police board. They can deal with it. How's
They
that?
they get in too much trouble. We won't go there. But then I do think, yes, I would agree that, you know, I think you maybe stretch it when you go to property, because we've seen, you know, a property, people come from all kinds of angles. But I think a deck, if it's part of a formal structure, I would agree a deck would most likely, for most people, would consider that a protected view. Right, as long as it's not, I get where Gail.
As long as it's a permitted deck and not
as long as it's a
deck, right?
permitted deck and it's not a new deck. You know, I agree with the kind of the comment around whatever you want to say is we're trying to create new views, so I can't pop up a new deck and go, I want the view now. But I do think that if you've had a deck for all this time, it was a permitted deck, then yes, I would agree in that it's a protected view. Then if something's growing into it, you should have the ability to speak to that.
Yeah, and John, just speaking for myself personally and not on behalf of the board, I think that you know, the KMAC taking on this additional function makes a lot of sense. It seems to be a good fit in terms of subject matter. And I agree with Chris that getting a full board staffed and then present at meetings can be a challenge sometime. Following on what Gail said, it sounds like there are potentially quite a few of these matters that are bubbling up every year in Kensington. So it would be it's additional level of activity. I think that, when you say 10 a year, that's more or less one a month. And there are some months when Kensington's Municipal Advisory Council doesn't meet at all. I don't think that that's a difficulty necessarily, but I think that this board could probably handle the additional
You
workload.
just want to have more reasons for people not to like you now.
The power. It's a power
I have
grab.
learned them, right? Yeah. So the more issues, controversial issues you decide, the more reasons people have not to like you.
I'm working on being famous. So Paul and Vita, did you have something more to add? I see you have your hand up still.
Yes, thank you very much, Lloyd. Just a clarification, if possible, from Tom Geiger. I was a little unclear what the resolution was as to whether or not we in Kensington, under the current ordinance or under this proposed revision, do we or do we not have a right to a view as determined by a court, notwithstanding state law to the contrary?
Well, the ordinance itself actually says that, you may, well, under state law, you're not entitled to a view, but, like John said, this is an attempt to get people to come together to restore a view. But one thing that's at the beginning of the ordinance is that the ordinance isn't intended to create any greater right to a view or access to a view than existed when you bought your property. So if you buy a house and, from a picture window, there's a big tree on a neighboring property that's blocking the view, you don't get a view from that because the tree was there before you bought your property.
I think a lot of this comes down to also evidence and proof, right? I mean, how does somebody show, what, and I guess if someone moves in, they better take pictures right away of what their view is to prove that they had a view, right? I mean, that's part of the issue is proof on these things. Let me ask the question too. I mean, so if I move into a house and I have a view, and there's a very young tree in front of me, and 5 years later, that tree is blocking my view. What is just aside from the ordinance for a second, what is, and let's take the existing ordinance and it's in place. That's what's existing state law and the existing ordinance. What is what is somebody's property rights? So I have a view when I move in. 5 years later, a tree is blocking this great view of San Francisco Bay from my living room window. To Tom.
Right. I mean, I think you do. Well, you have a claim to a view, and so you don't necessarily have that right, but you have a claim to a view, and so
under the existing ordinance.
Under the existing ordinance and under this new ordinance. I mean, that doesn't change.
Yes. So let's say if we had no ordinance under state law, without any ordinance at all, what is a property owner's right when that happens?
They really wouldn't have any rights unless the tree somehow was creating a nuisance, and that's not, and blocking a view is not a nuisance.
Right. So under state law, under state law, no ordinance. A tree blocks your view that you had when you bought the house. You don't have any legal right to go. You could go to court, but a court's not going to order somebody to cut their tree down unless the tree's forming some other nuisance, but not with regard to your view.
That's right. But with this ordinance, I mean, it lets you make a claim towards having a view that existed when you bought your house.
What effect does the general plan policy have on all this, though, that says that we are trying to protect views with regard to development? vis-a-vis development. Does that play into any of this in terms of anyone's claim?
Well, no,
policies that-
development's different. It goes back to development's different than trees. So I mean, I think that, you know, the county can definitely regulate development and protect.
Right, but can someone use that general plan policy in court and say, hey, the county has a general plan policy, at least with vis-a-vis development, that you know, that provides some degree of protection for view? Is that policy, is that something a court would look to in a civil action on tree disputes?
Well, I think they'd have to look at that in conjunction with whatever ordinance existed. I mean, I think, you know, the general plan is the blueprint for development and growth, but it's not, you know, the law itself.
With regard to trees.
All the laws have to be consistent with the general plan, but it's like if you know, if all you have is the general plan policy and no law to support that, then you're not going to get very far in court.
It seems to me that this particular provision here, this lights more first. I'm just looking here, comments too. If that this rebuttable presumption seems to be the most effective tool in in the ordinance, this rebuttable presumption of the tree board decision in court. So that is legally, that is a legal tool. That seems to me some new, it gives greater power to this tree board decision as a rebuttable presumption.
It does. Well, and that comes after, you know, if it's binding arbitration, and then somebody doesn't do what the board has ordered, then you can go to court and get that.
I understand. Yeah, if it's binding arbitration, then clearly you can go to court, and I think that's an important point. When two parties agree to binding arbitration, then you can go to court to enforce that arbitrator's decision. But if it's not a binding arbitration, there seems to be this rebuttable presumption that carries some weight in court.
Yeah, it would carry a lot of weight in court. I mean, it'd be, you know, if there was evidence given at the tree arbitration board, it would be hard to overcome that presumption in court because the arbitration board has already seen the relevant evidence.
Right. Now I want to address Kate Rauch, who of course fielded a lot of these calls, made a comment here in the chat about some trees and bushes may also need maintenance under CAL FIRE defensible space. Quick inspection could make, so I think it's important to add the county's looking at regulations on trees in general that would be in a separate ordinance that would apply anywhere countywide, where it's relevant. So I think that is an important, and I think that's going to involve a lot of discussion in updating that. I don't know, Ruben, can you talk a little bit about the sort of the broader tree ordinance discussion?
Yeah, I mean, you know, right now we have a tree protection and preservation ordinance that protects certain trees on certain properties. Based on the development pattern of Kensington, you know, a lot of smaller lots, not a lot of lots left that are subdividable or vacant. It's mostly built out. Under the current ordinance, like most of the trees in Kensington are not protected under the tree protection ordinance right now. You know, as you had mentioned, we are looking at updating the ordinance, providing some additional ability to remove trees that are located in extreme high fire hazard areas. I think a good chunk of Kensington is identified as such. So yeah, I mean, in terms of the tree ordinance right now, there may be some interaction between the protection, the tree protection, the view protection ordinance and the tree protection ordinance. But like I said, in general, based on the development pattern of Kensington, the lot sizes, the fact that most of the lots are developed and stuff like that, it's probably a low probability of a tree having to be removed because of the obstruction of view ordinance and being protected. I
know we've provided some direction that when we look at the countywide ordinance that you consider sort of the flammability of trees. I think remember that old ordinance, which is a very old ordinance, needs to consider those issues. Yeah, I want to get to the issue. I think there was some good, just so people understand that So just looking at them, which I just, Tom, these are to you. So the, this ordinance creates, I think you need to explain to people, what do you mean by making a claim towards having a view versus a right to a view? The ordinance gives this this appointed body the ability to make a decision that has a rebuttable presumption in court. Explain how that works.
Sure, yeah, so if the parties don't agree on binding arbitration, the arbitration board will issue a decision, which is basically like a recommendation. But it will be based on evidence that was presented at the hearing. And so then if somebody wants to go to court to make a claim to get their view restored, then the court is going to look at the board's decision and say, you know, not that I agree with it, but that's the decision that the other side is going to have to overcome for me to rule differently than the tree board did.
Right. So the ordinance gives vests some power in this tree board to the extent that their decision is a rebuttable presumption in court, which would not exist if that wasn't in the ordinance.
That's right.
Gail, you had some comment about, was it note about a court decision?
Yeah, I was just going back to my file, and I remembered that we had talked about several other communities that have ordinances that have gone through the court system and been upheld. And I did mention to you in my comment that there was a case in San Francisco where the US, I think it was California Appeals Court, did uphold San Francisco's ordinance in a case where somebody's tree obstructed the view of another, and the court found in favor of the tree obstruction. So I guess even though this, and Tom, you know, obviously this is your area more than mine, but clearly the state courts are still finding in favor of communities that have these ordinances. So there may not be a state right to a view, but they're finding that if communities establish their ordinances in such a way that upholds a certain values, then they're upholding the rights in certain cases.
So I want to remind everyone that the genesis for this was that people, there were people who believed that the existing ordinance, which basically pretty much leaves it up to people trying to work it out or go to court, to provide an additional mechanism before going to court through the county to resolve these issues, knowing that court is more expensive. And so that was the genesis for looking to other cities like Sausalito and what they have. And I don't know, Kate, you know, Kate, I see is on, who took a lot of those calls when she worked in our office. And before you came on, Kate, I was asked, you know, how often did this occur? I said, you know, we don't know every number, all the disputes that existed because they didn't have to go through the county. Did you want to provide any comment about how often you heard from people on this?
Sure. Although I want to also say that my other comment was as a Kensington property owner, not as a former employee of your office.
Yeah. Okay.
A lot. I mean, it was probably maybe over the years intermittently the number one issue. And I want to say that a lot of what I heard was that people were very confused by the ordinance, the TOV ordinance. And they were confused by many aspects of it, including what role the county played, which really was very, very little. And I think that I also heard from people that just struggled with the financial aspect of it. You know, I heard from people on both sides, people that were confused because they had neighbors asking them and telling them, you have to cut your trees. And I had to explain, no, you actually, let me explain how this ordinance works. They can't really say that to you. And then from the other side about, you know, I've lived here for so many years and these trees have grown up into my view. I mean, that was what I heard over and over, grown up into my view, grown up into my view. So, yeah, people have had in my time there, people had a very hard time with this ordinance. And I know Tom, I talked to him early on and trying to get clarity myself. And it's hard to help residents with an ordinance that inherently, it has no teeth. It recognizes, I don't know, does it even recognize a right? I mean, I didn't even really know how to talk about it often. So I tried to walk people through. And I also want to say that in the course that I was there, you know, some people did get resolution, and the ordinance outline, you know, kind of laying out, start by writing a letter, you know, did help. But there are many cases that went to court. I didn't get involved. That wasn't our role. People would ask me to recommend lawyers. I never ever did that. But I did hear back from people that rulings were made and resolutions were reached, and usually there was some sort of compromise that you know, restored at least some view. That's the feedback I got. I didn't, you know, I wasn't keeping notes or records on that at all. So I don't know if that helps or not.
I think it'll be helpful to, if KMAC is tasked with handling this, the opportunity for a public hearing at the library to be heard. And if you're thinking about filing something, knowing that there's going to be something on the agenda that you can see how it plays out, and the kind of expert testimony, so to speak, that will be elicited. I think a lot of that will go toward alleviating people's anxiety and emotional attachment to certain aspects of their home that will be productive in the long run.
And you know, the way I sort of view this is, without trying to use any legalese, that the ordinance as it's drafted with the changes gives greater protection to protecting someone's pre-existing view than if you didn't have these changes. I guess that's probably, I don't know, Tom, if you would sort of agree with, that's my sort of view and perception of that. In addition to creating a more defined process, it puts a little more tools in the toolbox about providing a mechanism to protect a pre-existing view.
Right. I mean, as Kay was talking, I mean, I think probably the easiest way to think of it is without this ordinance, if you had a view that was eventually blocked, there would be no way to get it back. But this ordinance really gives you an opportunity to try to get the view back, where you're balancing, you know, the view you used to have against the rights of a neighbor to, you know.
This is exactly why this is why most cities and counties do not have a tree view protection ordinance, because they're complicated. If it wasn't so complicated, there'd be a lot more of these.
John, can I just say one more thing? I'm sorry, I've been Zooming for 3 years and I still don't know how to put my hand up. I do think any arbitration board, there has to be the utmost care at figuring out how that board can be really, really objective, because trees are extremely emotional. And, you know, that's all really, I mean, I heard it in my office with you when I was working for you, and just sort of the emotion on both sides. Trees that block views, it's a very emotional for somebody to have a view and lose it.
Yeah.
They may also love
no,
views.
yeah, I think you're right.
And then vice versa, you have to, so people have real passions about trees as individuals, and somehow they have to be able to leave that aside and be objective in whatever they're assessing.
Yeah, I look at, I've experienced that too, right? With the development ordinance, that people have strong feelings on both sides. The protection of their view, both from a qualitative standpoint and also from a monetary standpoint at their home value. I think most realtors would say, you know, the cost will differ based on analysis, but that a home with a panoramic view of San Francisco Bay is worth more than a home that doesn't have such a view, a similar home, right? And likewise, people are very protective of their trees. And let me just say, I think both are important interest, right? That's why this ordinance is trying to provide some mechanism on that. Very different than when someone's trying to add on to their home, right? Although it's personal to them. They want to add on to their home. They feel that they have the right to get additional space for a growing family. Gee, why can't I do that? My neighbor is really unreasonable. You know, they have a view from their upstairs. Now they want to protect their view from downstairs. Look, we've heard it all. KMAC has heard it all. So we respect that there are really strong interests on both sides. And the idea is trying to come up with a mechanism or balance to protect it with someone who's your neighbor. Look, I live down on the Bay Trail at the marina in Richmond, and I have a great view. And the home I bought was worth substantially more from exactly the same subdivision home across the street from me that didn't have a view of the bay. So I understand why people protect their views and why they value them, but I also understand why people want to protect their trees. And so the purpose of tonight was really to get this input, which has been helpful and useful. And I think if, you know, bring it back to the working group for discussion of some of the issues that have come up tonight. I mean, you know, we're not here to rush it through, and we can come back with any possible changes to KMAC. I mean, let me get a sense for KMAC. And this is just a sense, knowing that there's still some issues maybe to discuss. Whether all of you feel, as a recommendation, whether having these types of changes, we're not holding you to all the specifics, but whether having these types of changes would be beneficial in Kensington to have an ordinance that has slightly more teeth and provisions in it.
Well, I personally think that it's a good idea to have an intermittent step that helps to resolve issues at the local level as much as possible, between neighbors if possible, informally, without the added expense. And I think that we'll be taking on sometimes difficult and obviously emotional issues from members of the community, but I sure as heck wouldn't want somebody from, you know, all the way out there in some other town in the county dealing with it. And you know, the county government has a bigger fish to fry, frankly. And it sounds like this is a local, very hyper local dispute that if we can guide people towards a resolution that will involve them, you know, a compromise, and everyone has to get along, I think that's a way forward. I think that as a KMAC member personally, and again, not speaking for the board, that I think it's a good idea. It needs some polish, obviously, and I think we need to have some more community input. We have people who are very interested are here tonight, but I think a few more opportunities for people to come and discuss would be beneficial.
Yeah, I'd second that. I think it's worth it, John. We've seen enough of these, right? And I think an upgrade to it, as Lloyd said, this just adds a step. It doesn't further complicate, quite frankly. It just gives people an additional option, right? And I think by putting the county in it, it gives it a little more teeth. So, you know, if somebody doesn't want to go to arbitration, you know, you don't want to quite go to lawsuit, there's somewhere in between. So this offers that. So I think it's worth it. And I'd agree with Lloyd. It's probably, you know, good or bad. Our next meeting is in person and we'll be at the library. So that would give everyone the opportunity to attend in person. So if, there are changes and Gail, if your team makes further recommendations, I think it's worth obviously that's why KMAC exists, is let's take the community feedback, see if we can make improvements, and then come back and maybe present it before we take it forward.
And community more community input's always good. I've also learned that at the end of the day,
We'll never get there.
yes, I mean, there were people who didn't want the planning view protection ordinance, right? They wanted the unfettered right to build. So, yeah, I think, there's always going to be a balance, and you never make a decision if your goal is to get everybody on board. That's not going to happen in a democracy. If there's going to be some differences of opinion, and that's okay. So the idea is just, trying to use our best judgment in all of this, because we're not going to resolve every difference, right?
And I just say quickly that, and you might have said this already, that we've been working on this now for almost 2 years as a committee. It's just taken that long to get the drafts through and the discussions. So I think it's good to have one more round on it after maybe the working group looks at it one more time. But I would say let's put it into action and see what the problems are, and then maybe regroup on revisions that are needed if there are problems with how it's being managed or administered. But I think the bones are really here. Tom did a really great job. I just want to really thank him for his work, and also the county staff, John's staff, and John, and that I think this is much improved over what we had as far as the criteria that people would be looking at and considering in any type of tree actions and treatments. So I think we're pretty close. That's my feeling. And yeah, I'm happy to have another round, but I'd like to move it forward.
I just want to tell, James raises an interesting issue about the tall trees on property owned by the Vatican. I assume I think you're talking about the what's it called? The
Carmelite.
Yes.
Yeah. So I don't think it's owned by the Vatican, but they actually, they actually own it. I don't even think it's the Diocese of Oakland, but it is. I know what you're referring to. And
I hope.
They have these. They're farther away. So Tom, it's a property owned by a religious institution, like a convent. They're subject to this ordinance too, aren't they?
If they're in the area covered by the overlay zone, they are, yes.
But I meant for this tree ordinance, within Kensington. They're in Kensington.
Right.
Yeah, I get. Yeah, if a tree in El Cerrito is blocking your view, I don't think this ordinance covers it, right?
Right.
But if it's in Kensington and like this, I can see that. Let me just say, and Joseph, we can talk offline. If there's an issue there, I've had contact with them before. I know they want to be good neighbors. So you can always raise it to us, and maybe we could reach out to them about trimming their trees. But they're subject to this ordinance too, it sounds like, and I know they want to be good neighbors. So
well, that's great. I mean, I'm looking at these trees and knowing what it costs to make an 80-foot tree 20 feet shorter.
Yeah,
it could be $100,000 worth of work. So.
Yeah, and I don't know what their money situation is, but I actually a few years ago had a chance to visit them on some issues, and it's I think they want to be good neighbors, and
I'm sure.
Yeah. So let us know about that, and we could try to reach out to them.
Okay, thank you.
And Andrew's saying how we publicize the KMAC hearing. We'll make sure we publicize it again on Nextdoor. Try to get something in the Outlook and KPOA. So we'll do that. Yeah, the link. We'll make sure that the link is a live link, hot link in the agenda, so we won't have that issue next time. Good. No, this has been good and very helpful.
Okay, it sounds like we are coming to the end. In the absence of anyone immediately demanding to be heard, I think we may call it here.
Come to item 6. I'll make a motion to recommend adjournment at 8:34.
All right.
I'll second it.
All those in favor?
Aye.
Aye.
Any opposed? Thank you to everyone for coming. This meeting is now adjourned.
Thanks all.
Thank you.
Thank you.